Thanks, everyone, and good morning. If you can't hear me, please wave your hand and I'll do my best to speak up. First, let me just tell you a few words about myself. As Dave mentioned, I grew up in Preston County, West Virginia. Proud graduate of the class of 1974 of Newburgh High School, which no longer exists, and went from there to West Virginia University undergraduate and law school. Went to Charleston thinking I'd spend my life in Charleston, worked for the state Supreme Court for about a year and a half, and then decided I wanted to try big city life for a couple of years. Went to Washington, D.C., and have been there for 30 plus years now. When I was young and got tired of feeding cattle at 5:30 in the morning before going to school in minus 20-degree weather, I decided I really didn't want anything more to do with farming. And of course, you know how these things come full circle. 15 years later, I bought a farm and I now raise cattle. So I'm kind of in Washington, D.C. through the week and in West Virginia on the weekends, repairing broken fences and looking after my mom and doing all those kinds of things. But to pay the mortgages and so forth, I do work at the Federal Energy Regulatory Commission. That's my day job. I'm director of the Division of Pipeline Regulation. And there's two ways to think of pipelines. One is the construction and operation. And I have a lot of history in working with that. I'm an environmental lawyer by training. But for the last 5 years as the director of the Division of Pipeline Regulation, I've really been more responsible. Okay, I've been more responsible for rates. So, but I do have, like I say, a good background in pipeline construction and operation. And as Dave alluded to, there's really three major segments to the natural gas industry. The first segment are the exploration and production folks, the folks who go out there and sign land up to lease if it's not already held by production. They drill the wells, they produce them, they operate the wells. Then there's a big segment that a lot of people call midstream, and that's comprised of many things. It's like the cryogenic facilities and so forth, like the Sherwood one out Route 50 here to the west of us a little bit. That includes both gathering pipelines and the big interstate natural gas pipelines. And then you have a third segment of the industry, which is really the folks, say for example in Charleston, who provide natural gas service to your door. They typically buy natural gas from and transport it over the large interstate pipelines. But I'm going to talk about the pipeline segment of this, and in particular try to give you a picture of how FERC works and in processing these applications with a focus on easements and eminent domain and the kinds of things that concern landowners. FERC was created by Congress, and as such, it has only the powers that Congress has given to it. No more, no less. And those powers include the ability to license certain types of hydroelectric facilities, to regulate certain types of interstate electric transmission rates, and is relevant here to regulate the construction and operation of interstate natural gas pipelines. FERC does not have jurisdiction over exploration and production. So when a landman shows up at your door wanting to lease or wants you to modify your lease to include a pooling agreement, that's not something that FERC has anything to do with. They don't have anything to do with well pads, and for that matter, they don't have anything to do with the gathering lines. The gathering lines are the kind of, if we could do a comparison, they're the county roads and the state highways that move gas around the state. The interstate natural gas pipelines that FERC regulates are really like the interstate highway system. That's a kind of a good way to compare the two. Most of the construction you're going to find in West Virginia, Pennsylvania, and Ohio through the development of the Marcellus and the Utica is going to be in the form of gathering lines. I think that a rough breakdown, there's probably 10 miles of gathering lines across the country for every mile of interstate pipeline. So many of the pipes that when somebody shows up at your door and wants to get an easement, they're probably going to be gathering lines, but some of them inevitably will be large interstate pipelines. More and more of those are proposed for the West Virginia area. FERC does not propose pipeline projects, nor does it build them. Companies come in and make this their business. They're the midstream folks. Some of those names are going to be familiar to you. Companies like Dominion, Columbia, EQT, they're all in the business of building these interstate natural gas pipelines, among other things. They make their money from transporting natural gas. FERC's job is really to evaluate those proposals that are brought to it, and Congress has set out a standard. They must be in the public convenience and necessity. It's really kind of a fancy lawyer-like way of saying, is it in the public interest or not? In evaluating these projects, the Commission acts much like a judge. We have rules of evidence. We have requirements that the pipeline company has to meet. People are allowed to intervene in these proceedings and take part in it. And at the end of the day, the Commission issues an order either approving the project or not approving it. And it usually approves it subject to conditions to protect the environment and other resources. There's typically a several-year lead time for these projects before the company brings them to FERC. And during that time, the pipeline company works to determine if there's customer interest. If they want to move gas from Doddridge County to, say, Cumberland, Maryland, are there sufficient customers in Cumberland who want to buy that gas to warrant building it? Those are typically commercial customers, exactly as Dave points out. They're often local distribution companies. It might be large industrial consumers. It might be power plants, things of that sort. During this time, the company is also looking at how it's going to route that pipeline. They're doing surveys to see if there are wetlands, if there are historical resources, if there are endangered species that are required to be protected under the law. And it's around this time that those of you who are surface owners in West Virginia or other states are likely to get your first visit from someone representing the company that wishes to build this pipeline. Typically, they're going to want one of two things. They're going to want either an easement, which is essentially a property right in your property that allows them to build these facilities on your property or across them. They may also want permission, usually separately, to conduct these surveys I just mentioned for wetlands, and they want to look at the terrain and all that kind of thing. FERC does not have rules pertaining to granting access. We're often concerned with those issues, but we don't have rules. That is really regulated on a state and local level by local trespass laws. And someone like Dave can give you a lot better answer than I can about what West Virginia's laws might entail there. But as a very general statement, if at that point in the process, if you don't want to let someone on your land, you typically don't have to. Once the company has done this background work, it'll file an application with the Commission. The company also typically goes out at that time and holds open houses in the area through which the pipeline is going to go. They do that to try to educate you about what they're doing, to try to see if there are issues or complaints. They sometimes reroute pipelines at least a little to take into account things they didn't know about and learn about. Usually about the same time, FERC starts an environmental review process, and they do what are called scoping meetings, and they come out to local communities, and this is an opportunity for community members to show up and register their thoughts, issues, complaints, support for the project. A transcribed record is kept of this, and the information that's provided in the scoping meetings goes into the environmental document that the Commission is required to prepare by law. It's usually called an environmental assessment. If it's short, it's called an environmental impact statement. If it's long, the environmental impact statement a project of any size, most interstate natural gas pipelines are going to have an environmental impact statement prepared. These are documents that are often 300, 400, 500 pages long, and they look at all kinds of things: soil conditions, the potential for slippage, and some of the things I mentioned before, like wetlands, cultural resources, endangered species. The public has an opportunity to comment on those. It's put out in draft form first, and then the commission finalizes it. And that's part of the record of decision on which it makes this public interest finding that I mentioned earlier. At the end of the day, the commission issues an order either approving again or rejecting the project. Very few projects are rejected. And some people look at that and say rather cynically, well, you know, this has all been determined in advance. And the argument that is opposite to that is, in 25 years of working with these projects, as the process unfolds, the issues with a pipe are typically fleshed out. You learn what they are, and so the project gets changed over time, sometimes a little bit, sometimes a great deal. And the commission has the authority to put conditions on whatever approval it grants. And so, like I say, the project often changes in its nature over time. If folks feel that the law hasn't been complied with, or that the commission has misconstrued or misunderstood the evidence in front of it, our decision can be appealed to the United States Circuit Courts of Appeal, which is the level right beneath the Supreme Court. That happens from time to time, and those cases can even go up to the Supreme Court, which is quite rare. Say a few words about easements. I don't know how I'm doing time-wise, but 5 more minutes. If I can fill 5 more minutes and hopefully say something a little useful. Again, when the pipeline company negotiates easements with landowners, FERC is not involved in that process. However, FERC looks much more kindly upon projects that are brought to it if the natural gas pipeline company has obtained voluntary agreements with landowners for a significant portion of the route. It does not like to see pipeline projects come in where, say, for example, if there's a 300-mile pipeline being proposed, that only 20 or 50 or 70 miles of easements have been voluntarily obtained through negotiation. It strongly prefers 100%, but recognizing that that's probably pretty much impossible most of the time, it really likes to see projects come in with a very high percentage of the easements having been voluntarily reached between the company and the landowner. Now, once the FERC grants a pipeline company an order for a proposed project, that company, Congress then set up the law so that that company has eminent domain authority. And it can file either in state court or I believe federal district court to engage in an eminent domain proceeding. FERC, again, does not involve itself in that process, but they do have eminent domain authority. Now, having said that, my experience has been that if a landowner, I think landowners kind of know their choices. If their particular piece of land is identified as something that might be crossed by a pipeline, you can come to a voluntary agreement, or if that route holds up through the permitting process, you're probably going to face an eminent domain proceeding. And my experience has been that companies work fairly hard. They don't always start out in the right place, in my opinion, but if landowners ably represent themselves or get good representation, they can. My experience has been you can get fair market value for the value of this impingement on your property rights. And that's something that I want to mention. As Dave mentioned, I've been involved in natural gas leasing up in Preston County. And one thing I've discovered is, the harder you contest these people and you find ways to challenge them, the more power you have. And you shouldn't be afraid to give representation, or for that matter, represent yourself, but really put a fair market value on what this easement is worth, and push hard to get it. I've certainly seen, I think of one case where I assisted a friend of mine some years ago, an older gentleman, and he had a 62-acre farm that was in the shape of a long, narrow rectangle, and a transmission line, electric transmission line, was coming overhead. His house was going to have to be moved or demolished, and basically, because of the way the pipeline was coming, or I'm sorry, the transmission line was coming right through the middle of his property, it was going to really make it very unusable for anything but a little bit of hay and grazing some cattle. And he had some ideas of putting houses on it, which was probably where its greatest economic value was. And the landman came in and offered him $100,000. And this went on for 2 months. The landman said, geez, we don't have authority. Bill gave me a call, and I just went out and talked to the landman. I worked up some numbers of what this was worth, and I told Bill in advance, this is probably really a $500,000 impingement on your property, and you should really hold the line. He goes, well, they're not going to bend. So I met with the landman with him and explained the reasoning and said, this is really a $500,000 project. This took place on a Saturday. I'm about to wind up here, Dave, if you're getting nervous. Okay. And so we agreed to meet the following Saturday at 9 o'clock to see what the landman thought of this, because he said, look, my company's simply not going to do this. There's absolutely no way. We're not authorized to go higher. And so we agreed to meet at 9 o'clock a week later on Saturday to see what his company said. Well, Monday morning, he shows up with a check for $400,000, and my friend Bill unfortunately fell over himself taking the check. I think if he'd waited another week or two, he would have probably gotten $500,000, because we didn't try to jack up the number on it. We just tried to come up with what this was really going to do to his property, given its location among close to several major towns in northern West Virginia. So, the moral of the story, and I saw that happen to a lot of landowners along this transmission line. So, from my point of view, the moral of the story is you really got to fight for your rights, and don't be afraid to assess what's really happening to you, and try to get the fair market value, try to get a fair deal, keeping in mind that these pipelines, particularly the interstate natural gas pipelines, there's a very high probability that those pipelines are going to be there for 50, 75, even I can foresee situations where that right-of-way is going to be in existence for several hundred years, because it's getting more and more difficult to site things around the country just because of the way land is getting fragmented. There are houses increasingly everywhere. It's extremely difficult to get anything built in the whole Northeast now because it's just so densely populated. And I think once you grant these right-of-ways, the odds of them going away, unless you negotiate in advance how it's going to go away, are very slim. So it's going to constitute probably a permanent impairment that is going to affect the value of your property in some way. With that, I'll stop, and I